Welcome this afternoon for our drug-free workplace policy PowerPoint presentation. And I'd like to get started as quickly as we can. And Suzanne, could we have the first slide? This is our policy statement. The unlawful manufacture, distribution, dispensation, possession, or use of an alcohol or a controlled or illicit substance is prohibited in the workplace. Now, that's one long sentence, but it's certainly a whole lot simpler than our 20-page policy that you'll be given after the program. And we'll start out with definitions. And there are 15 definitions in the policy, but we're only going to cover 7, which I feel like really affects you. And they're accident, alcohol, drug, employee assistance program, illicit substance, safety-sensitive positions, and volatile substance. And in the following pages, while we do have the actual definitions, accident, unexpected and undesirable event resulting in damage or harm. The resulting damage or harm may constitute an injury which requires off-site medical attention. Now, I'd like to talk about off-site medical attention for just a minute. If someone is out from the road department or the ambulance department, and they're out working off-site and they injure themselves, scratch a finger, bump their arm, whatever, and they go back to the emergency services building or to the road department building and receive first aid, that's not off-site not off-site attention. If you have to go to the emergency room or work well for medical attention, then that does become off-site medical attention. And alcohol, I think we all know what it is, but it has a fancy definition. Any intoxicating agent in beverage alcohol, ethyl alcohol, or other low molecular weight alcohols, including methyl or isopropyl alcohol. This includes over-the-counter and prescription medication which contain more than 0.5% of alcohol by volume. I went to the drugstore to see how many cough medicines or mouthwash or anything contain alcohol and what percentages. And I found some cough medicines did, but they didn't say how much. Some mouthwashes did, and they didn't say how much. So not being able to determine, I don't know how we can tell what contains more than 0.5%. But I think we should be aware that we can abuse these substances if we constantly are drinking them. The Employee Assistance Program, something that we've had for some time, but we want to publicize it more now. And it's an established program providing professional assessment of employees' personal concerns. And by that, addictions, substance abuse problems, and so forth. And it provides confidential and timely services to identify employees' alcohol or drug abuse. And we say confidential because they are confidential, although we do have, we must keep a record of them in a personnel department, but they're kept in a file and a lock and is not widely known, it's not put out. So referral of employees with alcohol or drug abuse issues for appropriate diagnosis, treatment, and assistance, and also follow-up services for employees who participate. And we would certainly encourage anybody who feels like they have a substance abuse problem or may have one to enroll in this EAP program, seek assistance, and so forth. By doing so, there are some conditions you have to follow, and we'll talk about them a little later. But it's a way that you can get behind this problem, and which will keep you from having problems with our policy in the future. Let's go on with the definitions. Illicit substance, prescription drugs used illegally or in excess of therapeutic values, as well as illegal drugs. Now, some people use illicit drugs and illegal drugs interchangeably, but illegal drugs, as we know, are something that's against the law, but illicit drugs includes the illegal drugs as well as the misuse of prescription drugs. And volatile substance, any glue, cement, paint, or other substance as described in KRS statutes. And I'll give you a good example. We've been doing some work on some stationery where Steve Smith was, name was listed on the stationery as Deputy Judge Executive, and now we have some white out, or actually yellow out, that we're putting on these and putting my name on it. And this morning, as you walked in the hallway there, you could smell it. I asked Jamie if she was getting dizzy from it. So it's just, there are things that can create problems for you if they're abused. Obviously, that was not abused. And then there's what we call safety-sensitive positions. And these are jobs involving exceptional care and due diligence in the area of public safety to the county's citizens and employees. And we have a list of which of our positions are considered safety-sensitive on the next slide. Employees of the county jailer, animal control officers, code enforcement officer, paramedic, emergency dispatchers and supervisors, emergency medical technicians, heavy equipment operators, personnel driving CDL regulated vehicles, and mechanics of CDL regulated vehicles, coroners, and deputies. There are other people who fit that position, but they don't work for the county, so I didn't bother to go into that. We all have to have training according to this policy, and I think this slide is pretty self-explanatory. 1 hour annually or an additional half hour. All current and new employees will be given a copy of the policy and will sign a form that they've received and read the policy. That's required by the policy. And when we get to testing, it's going to be done a little differently from the way we've tested in the past. We're going to have 3 test groups now. And the first are those whose jobs require a CDL, commercial driver's license. A second group, non-CDL, but in safety-sensitive positions. And a third group, non-safety sensitive positions. And the reason for that is that we are covered by federal law, a state law, and a court case. And the CDL is under the federal Department of Transportation. They have their regulations on drug and alcohol testing. The state's program has the balance of them. However, there's been a court case in which someone filed suit and said in random cases I shouldn't have to, and the court agreed with them and said only safety sensitive people will be taking the random drug test, and we'll talk about that a little bit later. But that's why we have the 3 people. There are 3 positions. The type of test for drugs for the CDL, we'll take the 5-panel drug test like we've always taken. That's been the standard. Non-CDL, we'll take an 11-panel drug test. The difference is that CDL measures 5 drugs. The non-CDL or 11-panel measures 11 drugs. They'll also include illicit substance and volatile substance. And then we have an alcohol breath test. It's not an alcohol blood test, but an alcohol breath test. And we do these at pre-employment, random testing, post-accident, reasonable suspicion, and then when we return to work if we've been involved in the EAP program. And the next slide shows the various test guidelines for CDL employees only. Pre-employment is the 5-panel. Reasonable suspicion is the 5-panel and or breath alcohol. Random is 5-panel or breath alcohol. And the reason for that is the CDL people are put into 2 distinct groups for drugs and another distinct group for alcohol, and they're picked at random for both of these. So they will have to be randomly tested for both alcohol and drugs. Post-accident will be 5-panel and breath alcohol. Return to duty, 5-panel breath alcohol, and follow-up 5-panel and breath alcohol. The non-CDL safety-sensitive employees take the 11-panel and breath alcohol test for all of their testing. And the non-CDL safety-sensitive employees do not take the random drug test. And as I mentioned before, there was a court case brought up about this, and the courts ruled that people who are not safety-sensitive employees would not take the random drug test. All others are the 11-panel and breath alcohol test. And on the next slide, pre-employment testing, we'll go through each one again so there's no confusion. CDL covered employees take the 5-panel test. All others take the 11-panel and the breath alcohol test. Random testing, as we said, CDL covers employees in both a 5-panel drug test and also another breath alcohol test. Non-CDL safety sensitive take the 11-panel and the breath alcohol test. Non-CDL, non-safety sensitive, there's no testing required. Now, post-accident testing, this is where we get into a bit of a change in the guidelines from what we had done before. We start out with referring to the qualifying event, and basically a qualifying event is the accident. And then following the accident, there are 4 situations which can require testing. On or off the county's premises while on duty, if the accident requires off-site medical attention, if you have to go to the work well or the emergency room for medical treatment, or you're involved in property damage of $500 or more, you're required to take testing. Also, if a safety violation occurs and death or serious injury did or could have resulted. For example, if you ran a stop sign, safety violation, and serious injury did or could have occurred. And finally, when an employee cannot be ruled out or discounted for causing a serious vehicular or other type accident in which death or serious injury or major damage occurs. And an example of this would be if you ran somebody off the road. You actually weren't involved in an accident, but you ran somebody off the road. They hit a tree and there was serious damage to them for it. And someone saw you doing it and so forth, that certainly would require a drug test. Now, there are some exceptions to drug tests. Cumulative or gradual onset, such as carpal tunnel, respiratory diseases, skin disorders, so forth. Or employees can be discounted as contributing factors. The weather, insects, bee bite, bee sting, toxic plants, poison ivy. Road department people who catch poison ivy don't have to get drug tested anymore. And employees who can be discounted as a contributing factor had injuries occurred in a physical fitness or a training event if they were performing as instructed. Somebody doing some physical fitness with an instructor and all of a sudden they grab their back and say, "Oh, I'm hurt." They don't have to be drug tested. Now, there is one thing. The county judge executive or his designee can require testing in any of the above exceptions if he wishes to do so. Now, let's talk about reasonable suspicion. This is based on a belief that an employee is using or has used drugs or alcohol in violation of this policy. And this is more difficult to determine than the others. And this one requires a basis or a belief that we have a reasonable suspicion that they're using drugs or have violated this policy. It has to be based on, as we see in the next slide, some of the bases: direct observation at work, direct observation of symptoms at work, where a person is slurring their words, stumbling, abnormal contact, erratic behavior, or report of a drug use from a reliable source. Next one, please. Evidence of tampering with a drug or alcohol test. The employee caused, contributed to, or was involved in an accident at work. Evidence an employee used, possessed, sold, or transferred illegal or illicit drugs or alcohol on county premises or while operating county vehicles. And those are the basis, and then we have a process we have to go through. And this process is required before ordering a reasonable suspicion. First thing you have to do is notify the judge executive or his designee. Then review of the policy or procedure by department director and judge executive or the designee to decide, was this a really reasonable suspicion? And we can't quite get there until we complete the reasonable suspicion form. And although I don't have it in this slide presentation, in the notebooks that'll be handed out, each of you will get that. It's just so small that we won't be able to see it here. But it has about 3 pages, and you must go through all these things and fill it out completely before you can proceed. And then the observing supervisor notice applies the employee of the drug test and accompanies the individual to the test facility and remains there with the employee until the results of the test facility, results of the test are known. An employee tested positive for alcohol or drugs is allowed to enter the EAP, who is allowed to enter the EAP, may return to duty under certain circumstances. Confirmed enrollment in the EAP program, test negative within 45 days of the first test, sign a return to work agreement, and agree to submit to unannounced testing for up to 1 year after returning to work. And here we have unacceptable test levels. And in the breath alcohol, there are actually 2 different levels that we use. For the non-CDL people, it's greater than 0.02. For the CDL people, it's greater than 0.04. Again, we have a federal law regulation concerning the CDL, and we have a state law concerning non-CDL. Illegal drugs, any detectable level. And prescription drugs, if they show up, that's determined by the Workwell Medical Review Officer if you're in violation. That's a licensed physician who has a background in substance abuse. And the disciplinary action with possible termination. First-time failure of a drug or alcohol test may or may not cause termination. Excessive absenteeism, tardiness, or poor work quality as a result of off-duty use of alcohol or illegal substances. If that affects your work, then certainly you're subject to possible disciplinary action, and it could include termination. And the intentional misuse of prescription drugs or volatile substance. Also, off-duty use of alcohol, illegal substances, or intentional misuse of prescription drugs or volatile substances when on call. You know when you're on call, so you have to stay away from them. There are also certain actions which require termination. failure of a drug test for detention center employees. They have a zero tolerance, so if anybody there fails a drug test, they're automatically terminated. All others, second failure of a drug and or alcohol test. You're given one chance. You may be given one chance. If you are, and it happens again, you're gone. Obstructing of a testing process. For example, you're scheduled to go down and have a random test or something like that, and you send someone else in your place, or attempt to do so. Or failure to cooperate with any part of the testing process, which means that if you're given a breath alcohol test, you don't provide enough breath for the machine to pick it up. Or you won't provide enough urine for the drug testing. In violation of the policy of unlawful manufacture, distribution, dispensation of alcohol or controlled or illicit substance in the workplace, automatic termination. And failure to follow the EAP treatment plan. If you go into EAP and you fail to follow that plan, it's termination. And then when you're off duty and have a possible callback, there can be misuse, and this is what this is going to cover. When an employee is called back to work, he or she must report to his supervisor any off-duty use of alcohol in the prior 4 hours. Now, we can't say you can never, an off-duty, be using alcohol or something like this, but if you're unexpectedly called back, you need to report to your supervisor that in the last 4 hours I've had 6 beers or whatever. And medically prescribed use of a controlled substance. If you're taking medication, you took something that has a tendency to make you drowsy or create a problem, this needs to be told to your supervisor. Now, what happens if a person fails a test for violation of the policy? The first thing is the employee will be suspended without pay. And following an investigation, the employee will be notified of his or her status. And that may be that you are given one more chance if you enter the EAP program. That may also be that you have been terminated or you will be recommended for termination. If an employee fails a drug test, he or she may take that test again at his or her own expense. And if for some reason that shows that they're clean, that the first test was in error, the county will pay for that second test, and the employee will be allowed to proceed as if the first test had not provided. If they fail the second test, obviously they pay for that. They have paid for that test up front, and they're gone. Now, the county reserves the right to do some searching with reasonable suspicion. And again, we say with reasonable suspicion. The county can conduct unannounced searches for controlled substance and alcohol anywhere on county property. That includes lockers and file cabinets, desks, stationary containers, county vehicles, and equipment. And the county sheriff or deputy will be in attendance. That doesn't mean that the sheriff makes the inspection. It means that the sheriff's in attendance. We can make this the search ourselves. Again, it's not something that we do without having a good reason for doing it. Now, the Employee Assistance Program, which we mentioned before, we'll review it again, has professional assessment of the employee's personal concerns, and this is basically due to substance problems. Confidential and timely services to identify employee alcohol and drug abuse, and referral of employees with alcohol or drug abuse issues for appropriate diagnosis, treatment, and assistance. And we will be putting out flyers on department bulletin boards to make people more aware of this. We have had it all along, but I don't think we have publicize it as much as we're going to. Now, if an employee, with the next slide, if an employee voluntarily seeks this assistance, they may contact the EAP at this 800 number here, and somebody's available 24 hours a day, 7 days a week. And employees who voluntarily report a substance abuse problem prior to being required to take a drug or an alcohol test may or may not be subject to termination. Again, normally they would be given the option of going into the EAP program. If, when they're told it's time for you to take a drug test, oh, I want to enter the EAP program, that doesn't count. And they sign a substance abuse treatment plan form, which further defines a condition of continued employment. Another issue, employees charged with drug or alcohol criminal charges or convictions shall notify the judge executive or his designee within 5 days of this taking place. And then the judge executive will make a decision on the outcome of this within 30 days. And now we come to the drug testing process. And it's a little different from what it was before, but it's not a great deal. We have the daytime process when Workwell is open, and they're open from 7 o'clock to 4:30. We fax the test request to personnel and Workwell, and there's a test request form which you'll get a copy of in the notebooks that we hand out. And when an employee is sent to Workwell with an on-the-job injury, they should have a test request with them. But sometimes it gets a little hectic after an accident, they may not have it. Workwell may deem that a test is necessary because they know what the rules are. They test more people who are in substance abuse or drug-free programs than just us, so they have a pretty good feel for what goes on. And if they feel that one might be needed, they will contact the personnel or payroll clerk for determination. If Workwell does not call the personnel payroll, no test will be given. So I think it's very important, if we feel that a test needs to be given, that we have that test form go with the employee. Workwell will notify payroll and personnel clerk of the results of all tests. And the payroll personnel clerk will then notify the department heads. Reason we do that is because with this, we must be able to show that we have the control, one central location of all our testing. So that's why it comes to personnel and then is distributed onto the departments, which is a little different from the way it's been done before. Each department got theirs back and we had no central location. Now in the off hours, and weekends, Hardin Memorial Hospital emergency room is a place that we send people for drug testing. The emergency room people will perform the drug test, and the sheriff or sheriff's deputy will perform the breath alcohol test, because the emergency room has no breath alcohol test that they give. And the supervisor will send a test request with the employee to the emergency room. Emergency room will collect a sample if the person is treated for a post-accident injury with or without a test request form. They're going to take, if you're there to be treated for an accident, they're going to take a sample. Then the next slide, Suzanne. The ER will send a sample to Workwell the next working day and report results to the personnel payroll department, who will contact the appropriate department director. Now, we have to, as department directors, supervisors, we have to contact the sheriff, and there's a number where you can contact the sheriff's office. The sheriff's deputy will perform the breath alcohol test and report the results to the personnel payroll clerk. the next day. I'm sorry, that's wrong. They will report those to the judge executive's office upstairs, and we will then take them to the personnel payroll clerk. And we have several forms that you will be given a copy of. First is a receipt of a copy and certification of having read the policy form. When you go through orientation, or when a new employee goes through orientation, they will be given a copy of the policy, which is part of the personnel handbook, and they will be required to say that they have read the policy, and along with some other things. But there's that form. There's the test notification form that we talked about, the reasonable suspicion form, a return to work form, which when a person has completed their EAP treatment, they will have a return to work form that they will bring with them, and a substance abuse treatment plan form. And that are the highlights of our plan for drug-free workplace.